Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Ha-ha. Oh, 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 oh. Everybody say, ah. Oh, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, yeah. Enough to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Eunice. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Eunice. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyina. Uya matinyina. Uya matinyina. Oh, uya matinyina. Yeah, so uya. Uya matinyina. Uya matinyina. Yeah. Uya matinyina. Uya matinyina. Say, I call you Jireh, say. I call you Jireh. Lord, my provider. I call you Eunice. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. William Miguel, come here. 1, 2, 3. I can breathe without you, say. I can breathe without you. I can move without you, Lord. I can move without you. Who am I without you? Who am I without you? Say, I can live without you, yeah. I can live without you. I can breathe without you, Lord. I can breathe without you. I can move without you, yeah. I can move without you. Who am I? Who am I? Who am I? Who am I? We are my thing now. We are my thing now. We are my thing now. So we are my thing now. Hello, lovely people. It's another Saturday afternoon here. We're right in the month of May 2023. We're back with you with the community and the law. My name is Kwaku Frimpong, and I have the duty and the pleasure to welcome you to the show. I'm going to be with you for the next 2 hours, and we're going to look at the question that says, what are my options to remain in the UK legally before my student visa expires? Now, all you students who are here studying, there's some real good news for you. So join us on the program, the community on the law, as our resource person, Charles Asmah from BWF Solicitors, takes us into finding answers to this very particular question, plus other things that will come along with it. And once again, I want to say, come, let's together join in the community and the law. Hello once again. I welcome you to another edition of the Community and the Law. My name is Kwaku Owusu Frimpong, and today we are going to have a very critical question answered. We're looking at how students in the UK who are coming to the end of their stay here in the UK, how they can legally remain here before the student visa runs out. And of course, there are other things that we want to look at as well. We shall be picking your questions and your comments. Now, listen, we are live on BWtv, we're live on BW Radio, we're live on BWF Solicitors on Facebook, YouTube, and all the social media platforms. Once again, my name is Owusu Frimpong, and today my guest is another friend and brother from BWF Solicitors, Charles Asmah. He's a lawyer with BWF Solicitors. And on the community and the law, again, we are looking at what the options to remain in the UK for students before their visas expire. Now, then again, we also be looking at our nugget where BWF solicitors set something out in the environment, so to speak, and we talk about that and we discuss all those things. But before then, let me say that BWF solicitors is at 214 to 218 on the Tottenham High Road, Seven Sisters, North London, N15 for NP. They work from Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Now, when you go to them, you have the opportunity of getting all your questions answered. When it comes to immigration issues, you have BWF solicitors answering all of them. When it comes to other legal matters, family and all the other bits, when you're getting married, when you're getting divorced, what are the options with you and for you when you're looking at the nationality aspects of the whole thing. Now, going to court, BWF solicitors can have barristers to accompany you to court. So talk to them, 0208 493 7340 or 077 127 61884. So we are here together on the platform. We're going to take a few messages and then we say thank you to BWF solicitors. Then we go into our thing. Now, first of all, let me tell you about Sawyer Nano and Sons Company Limited, a real estate organization in Ghana at Community 25 extension of the Aplao Road going to Tema. They have various housing types they are providing you. So if you are interested in investing in a property in Ghana or going to buy a house to live in, the facilities are so wonderfully good. The internal and external security available, concrete road network, they have a gym, they have a pharmacy, water fountain so you can go relax. There are shops, there's a general car park for everybody in the community, there's a forest spa, an event center, we have a swimming pool also available for you. Internal road network is solidly made. Then they also provide you with electricity that comes from solar systems. So definitely you will not be paying too much for your electricity needs. That's that. They have 2-bedroom detached houses, as you can see on your screen now. 2 bedrooms, or both rooms and suite. Paved parking space, plasterboard ceiling, ceiling fan air conditioning, solar power, electricity supply, stylish master bedroom ceiling with LED and spotlights and the rest of it. They also have 3 bedrooms also available. You can see on your screen next that these facilities are super for you. Now, this is the 3-bedroom you see on your screen, so well laid, so well designed, and it's got all the facilities that I mentioned earlier on. Now, this is the economy. Then they have a 3-bedroom detached house that's a bit on the high side when it comes to budget-wise. TV points in bedrooms and living room. They have a WC for visitors, kitchen and store with shelves and everything, AC point wiring. You have all these facilities, and what I mean is the city of favor is giving you something so real wonderful. Now, those of you who have bigger families, 4-bedroom detached house available with all the features that I mentioned. They have the executive ones as well, so you can make a choice of that and go a bit higher on your budget. That's what City of Favor provides you. Now, how do you purchase a house from them? What you do is browse a selection of building on their website. you complete an application form, they will send you an offer letter. Then you go ahead to make a payment. Then they allocate your property to you. It's so straightforward. That's what the City of Favor is all about. So take the website is www.swana.org swana.org.gh.com, and you can call them in Ghana 023355 or 0023354256350. Accuracy is the key. That's what they say. So buy from them and you will not regret. Now, next I'm taking this out of the way and I'm looking at how you can prepare and pass your English language test for IELTS and the SELT. For your immigration purposes and for other applications. Pass very well with the experts and prepare with the experts, so to speak. KT Educational Consult is what I am recommending to you. Call them on 07596 620-154. I say the number again, 07596 620-154 or 07512 644-041. Now, today is the 13th of May 2023. Now, in about 15 days, there's this wonderful musical concert that's coming up in Reading at the Pavilion, 1432145 Oxford Road in Reading, RG17UY. Is the Emmanuel Praise by the Alexa Champon Ministries. Now, it's going to feature Alexa Champon, Diana Hamilton, and Minister OJ. Now, this event is coming up to solicit for funds to buy incubators and other hospital equipment for hospital in Ghana. So you would want to be a part of it. Have fun, praise the Lord, and also support a worthy cause. £50 VIP, £40 double, £25 single, and £15 for children. So let's meet on the 28th of May at the Pavilion Reading for Emmanuel Praise 2023. For further information, call 07447 417321 or get your tickets from www.alexachampon.com. Now, with this out of the way, let's say thank you to BWF Solicitors, our main partners and sponsors, and we'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, a trusted legal partner.
Welcome to City of Favor Estates, developed by Sarenano and Sons Company Limited, located in Tema Community 25 extension off the Tema Aplau Road. City of Favor Estate offers 2, 3, and 4 ensuite bedrooms on 118, 138, and 178 to 190 square meter lands, respectively, to give you the needed space. Our gated estate homes are designed with you in mind and have all the necessary amenities located in a serene environment with security. You too can be a homeowner at a price that suits your budget with flexible payment terms. Choose City of Favor Estate for peace, comfort, and safety. Reach us on 0542 563 250 or 0243 235 518.
Alex Champong Ministries presents Emmanuel Praise on Sunday, 28th of May 2023 at the Pavilion, 143 to 145 Oxford Road, Reading, RG1 7UY. Hosted by Alex Champong. Guest artist, Minister OJ and Diana Hamilton. Doors open at 5. Tickets are £25 single, £40 double, £50 VIP, which includes a VIP seat, parking space, meet and greet with the artist, pictures with the artist, VIP snacks and drinks, and the £15 concession rate for children from 4 to 16. Get yours on alexichampong.com or call +44 744 741 7321. Emmanuel Praise with Alex Champong, Minister OJ, and Diana Hamilton. Come praise the Lord with us.
Okay, lovely people. We are back in your stride. It is a community under law. Let me say good afternoon to Ben Kusi Pilolo. It's been a while. We haven't heard from you in a very long while. Nana Kuya Abriye Ajimai, thank you very much. Ben Kusi, that's Pilolo. We say hello, Brakweku. Then we also have Tilly Duma calling out people to come and join us there. Nanajima Tilly is calling you. Please come on board. Kofi Nat, back in Mayor 1. Are you there? Covenant Grace. We have Ibn Ose, Ezekiel Johnson, all the people we're calling. Tilly is asking you to come join us. Margaret Du Mensa. Of course, Tilly, I'm here, and thank you for doing that. Sandra Fraser, also thank you for doing your usual wonderful job, telling us where BWF Solicitors is and all the other details, the telephone numbers, and all the other bits. They are on the platform there. So please come join us and let's move together and do that. Now let's look at our nugget that we have BWF Solicitors give us earlier in the week. Now, it's talking about domestic violence. The domestic violence concession under the UK immigration rules does not cover partners under the skilled migrant worker route. They cannot therefore rely on the concession to settlement, even if they suffered domestic violence by their partners. This is because such spouses are not considered to have legitimate expectation to live in the UK permanently. The concession only covers routes under Appendix FM, those who are here as spouses, refugees, and Appendix EU, that is after Brexit. This one is quoted from the SWP versus Secretary of State for the Home Department 2022 case, the English and Wales High Court case number 2067 admin. So I'll read that again as you see on your screen. The domestic violence concession under the UK immigration rules does not cover partners under the skilled migrant worker route. They cannot therefore rely on the concession to settlement, even if they suffered domestic violence by their partners. This is because spouses are not, or such spouses are not considered to have legitimate expectation to live in the UK permanently. The concession only confers routes under Appendix FM, those who are affected, refugees, and Appendix EU, that is after Brexit, those who have come in to settle. So, very, very soon, I am going to ask the lawyer, our guest, our friend, and our brother, lawyer Charles Asmah, to do the explanation for us. Rebecca Amoakon, thank you very much for joining us. Thank you for sticking with us. Invite other people. Tell them we're live on air. Tell one person to tell the other to say that we're live on air. And I just want you to do something real quick for me. Please share the link. So pick it up, put it in your network, and let people know that the community and the law is on there. Now, today, as we have mentioned, we are looking at the question of what students who are coming close to the end of their legal stay here in the UK, what they can do to make sure that they don't live here illegally. What are the chances? What are the options for them? We shall be looking at those things. So just get people to come around and we will talk about that. And again, if you have any question, if you have any issue, you have any concern that you want the lawyer to really address for you, please don't hesitate to share it on our platform, either on Facebook, YouTube, and all the other platforms we are on. Today, unfortunately, our text line and the WhatsApp line is not active, so we shall be taking every comment right on the platform. So take note of that. But before we bring in Lawyer Charles Asmah again, I'm repeating the question. What are my options to remain in the UK legally before my student visa expires or runs out? At this point, we say and take another message from BWF Solicitors, and we'll be right back. Okay. We are right back, and at this point, let me quickly bring in my friend, my brother, and lawyer, our guest for today, lawyer Charles Asmah, who is from BWF Solicitors, and our guest today. Lawyer Asmah, good afternoon.
Good afternoon, Ragoku.
Lovely Saturday afternoon to you. How are you doing?
Very well, thanks. How are you too?
I'm very well, thank you. Um, the sun is out, summer is right here with us, of course, so we're quite happy. Yes, I think I will ask you to say your hellos and your greetings before I just delve into the deep end of it and ask you to help us with the nugget for today.
Thank you very much. Yes, so a very good afternoon to you, viewers and listeners. We have met once again on the platform to learn about the law. Very important. So thank you for making time and stay put and let's learn together.
Well, thank you very much, Lawyer Charles Asmah. Thank you for your kind introduction. Welcome. Now, the nugget we had this afternoon talks about domestic violence concession. Now, under the UK immigration rules, this case that we have picked up here says it does not cover partners under the skilled migrant worker route. Those people cannot therefore rely on the concession to settlement, even if they suffered domestic violence by their partners. Now, we know from your previous lessons you have given us that people who suffer domestic violence can make an application to the Home Office and they will be given indefinite leave to remain in the UK. This is one exception to the rule. Why is it so? Would you be able to take us through it?
Okay, thank you very much. So we have a very important discretion that the Secretary of State allows for people who have to um, jump the process to settlement. And here we are looking at people who have suffered domestic violence.
Mhm.
We know that domestic violence is a very crucial experience, and that the government takes it very seriously, in that such events or happenings in the homes should not be allowed to continue. So, where people are abusing their spouses or partners, and the proviso is that if you, because of what they may lose out, the other partner, who is the victim, is still quiet and unwilling to speak up because of what they may lose in terms of their immigration status. Government says that on that basis, there are provisions in place to ensure that those people are supported, so they get out of that situation, and the government helps them to acquire their stay. In this case, they can be fast tracked to settlement. Now, this only applies to people who have entered the UK under Appendix FM. So here, your um, spouse make an application for you to join them in the UK, and once they come to the UK, they go through, or you met such treatment to them. There are people who have also come to the UK with their spouses. So we have students, we have skilled worker migrants, and so on and so forth. And therefore, somebody would ask, does this also apply to me? Because I'm also here in the UK, my spouse brought me, and I'm going through this. So, what we are looking at in terms of the nugget is that even though domestic violence route is open to partners, it's partners who come under Appendix FM provisions or applications. And therefore, if you are a skilled worker migrant, so you come to the UK under the new program to work, and you join your partner comes to work, and you join that partner. Either you came together or you came later. If you are experiencing domestic violence, the presumption is that you will not have the same treatment as people who came under Appendix FM, because you, the partner of a skilled worker migrant, you don't have automatic expectation to settlement, because if, for example, even though the program itself allows for that, you as a partner, the law does not contemplate that you will have that settlement, and therefore this does not apply to you. Somebody will say, well, then the law is not being fair, but it is what it is at this point. So it says that the concession covers routes under Appendix FM. And here, those here as spouses of such other Appendix FM visa holders, refugees, and Appendix EU. So Appendix EU here, we are looking at those who come under um, European rules or EU rules, those who come under Appendix FM provisions, those who are refugees and their spouses are in the UK joining them, those ones have expectation of settling one day in the UK. But skilled worker migrants, even though the law allows you to settle one day, it does not contemplate that the partner will also have the same treatment as that of other law.
There's a question that you have just mentioned it, but it baffles me. What I'm asking is now you give me permission to live in the UK, and when I stay on that for 5 years, I'm allowed to apply to settle in the UK. So obviously, if I am with my spouse, the expectation is that if I have spent 5 years on that particular visa, I would want to settle in. So there's an expectation, isn't it?
There is, but that expectation is sort of narrowed. And you see, when these laws are handed down or rulings are handed down in court, somebody will ask why. I mean, there seem to be um, uh, mismatch of how we apply the rules. But again,
Mhm.
it is what it is. The judge says that if you came under um, any other route apart from Appendix EU route, or if you didn't come as a partner of a EU treaty um, right person in the UK, relevant person under EU, if you didn't come under Appendix FM, such that your husband or wife already has settled status and you were joining them, or they were British citizens and you were joining them, and again, if you didn't come in as a partner of a refugee, then in this case, you don't have legitimate expectation. So we have to then define legitimate expectation. Legitimate expectation in this case will be such expectations that are not conditional. So that if your husband or wife, your partner has settled status, the presumption that you will have settled status. If your partner is exercising treaty right and you join them in the UK, they will continue to exercise treaty right, and therefore you have that legitimate expectation.
Mm.
If your partner is in the UK based on refugee conventions, then you have legitimate expectation that you will remain in the UK with your spouse or partner. Now, you are coming into the UK, for example, as a student. You don't have that legitimate expectation that you will remain in the UK and have permanent residence. And again, that is the same principle applied under Appendix skilled worker um, provisions. So that if you are coming in as a partner of a skilled worker, even though the skilled worker has expectation that one day they will remain in the UK, you, the partner, may not have that expectation because it's likely you will return. And
Okay.
it is
So,
what it is.
does it mean that, for instance, if I've been with my partner and we have spent 4 years, in the fifth year, my partner is expecting to actually run or apply for settlement, and there is domestic violence. Now, is it because, or by stretching it, if I'm in the fifth year, would it be considered that I may have an expectation to live in, and when I'm suffering domestic violence, I could put in an application at that point?
Right. So what the rules are at this stage is that, or are that domestic violence provisions apply to such routes, Appendix FM, refugee convention individuals, and also Appendix EU individuals. Therefore, if yours does not fall under one of these, then even if you are suffering domestic violence, government can take steps to help you to avoid or to overcome that whatever is happening in terms of the harm being caused. However, you cannot take advantage of that situation to fast
To
track
apply for
your
it
stay
immediately,
to
so you not
become
have to wait.
permanently settled in the UK.
Okay. All right. Well, thank you very much, lawyer, for that extensive explanation. Now, viewers and listeners, if you have any question, you can put that on the platform on the chat there. We're live on BWtv, live on BW Radio, live on YouTube, Facebook, and all the other social media platforms. And what we're talking about is the domestic violence concession under the UK immigration rules. And the law says that it does not cover partners under the skilled migrant worker route. They cannot therefore rely on the concession to settlement, even if they suffer domestic violence by their partners. This is because such spouses are not considered to have legitimate expectation to live in the UK permanently. The concession only covers routes under Appendix FM. Those here are spouses, refugees, and Appendix EU, that is after Brexit. That's what our lawyer has graciously explained to us. Now, with that, I think the door is open. The opportunity is now ripe for us to look at the question we have on our hands. What are my options to remain in the UK legally before my student visa expires? Now, people come into the UK to study, to enhance their knowledge, to develop themselves, and also to create more opportunities for them career wise. Now, when you live in the UK or you come here in the UK to live and go to school, there is a limit to the stay period or the extent or the amount of months, days, or the period you can live here. So it will expire at a point, one way or the other. Now, what are your options? If it's about to expire, what are the options available to you? Can you extend it? Can you change into a different route? Can you just stay in and say that after my application, I'm going to do X, Y, Z? These are questions that bother the minds of many a student. And I believe that Lawyer is ready and apt to answer them for us. Lawyer, what are the options available to students?
Thank you very much. So, students come to the UK to study, and once they have completed their course, they are expected to return to their home countries to support the development of such countries. Now, what it is that you are in the UK. Sometimes you want to acquire some skill so that when you go back to your country, you become much more productive and able to contribute. So, having finished or completed your studies, you wish to stay on. But what are the options available to you? Because you have to be legally resident in the UK. You don't want to take chances. So, just like anybody at all who is already in the UK legally. So, first off, your student visa allows you to legally live and work in the UK per the
Mhm.
rules of your or the conditions of your leave. But before it expires, can you continue to stay or can you switch? And the starting point is that yes, you can switch to other areas as long as you ensure that it is done before the leave expires.
Now, so if you talk about other areas, what will be the options? Can I um, take another student visa? Can I move into any employment, or what? What can I do?
Yes, so the first option is you have completed your study. Prior to it might be that your study allows you to move on to other studies,
Hmm.
i.e., PhD or masters. If you did undergraduate, you can move on to masters, or you can move on to a PhD if you did masters. Then in that case, you need another visa to be able to continue.
Okay.
The chances are you may be asked to go to your home country to apply to come back to continue. It
Hmm.
is also likely that you'll be given the opportunity to extend to continue, depending on how the arrangement is with the institution.
Okay.
In that case, you have two options. But we are looking at somebody who wants to have the option of doing everything here. The
In
good
the-
thing is that the government has introduced the graduate route program so that once you have completed your course and you want to acquire skill in the UK before you return to your home country, you
mhm.
can, um, provided you completed the course um, fully, and again, you were not referred on any of the modules. That's
Okay.
what I mean by you completed fully. So, first attempt in that sense. And so if you are supposed to complete by June, you have completed by June, pass all your papers or exams, and you have gotten what you need. In this case, you'll be able to apply for 2 year post-study um, leave to remain. In this case, you don't need any sponsorship from anybody from the university. It is you saying that I want to remain to acquire skill because it's a program the government has introduced
Okay.
for foreign students. So you acquire 2 year skill from the UK so that when you go back to your country, you can contribute meaningfully. So let's call it work experience. Now, with that work experience, you get the visa and use it to apply for a job to acquire experience. And
Experience.
that's really, really flexible. And all that the government expects from you is that you are not bonded by any foreign organization where you have to keep to the conditions of your bond or sponsorship
Right.
or scholarship. And again, you have to have completed your course and passed all your papers once. So that's
Okay.
one option. 2 years. However, after 2 years have expired, you are expected to go back. So it's not a case that we use the 2 years to with a view to become settled. No, it doesn't allow you to do that. The next thing is, whilst a student, you have found a job and you have been lucky, and the company wants to sponsor you. The company will give you sponsorship. And in this case, you can switch from student visa to work visa, i.e., any industry at all. But you need sponsorship from that employer. So in this case, you need the job first before you can apply for the visa, compared to the grad scheme where you apply for the visa and later apply for the job. Now, we have to pay attention here. What it means is that if you switch, you may not be able to remain on the student arrangement, because in this case you don't have student visa per se. You have switched to something else, and you have to be working full time potentially. So if you are working full time, how will you then continue to study full time? You may not be able to, and therefore it's likely you have to trade off your um, studies for this new option you have chosen. So that is something we have to take
Take
note
note.
of.
Okay. Now let me ask this. Maybe a little step back. Now, you said that you have to complete your course fully. Now, I have the expectation of carrying on and doing a postgraduate course or a study in the UK. So between the time that I complete my first course, whether I'm a graduate, a master's, prior to the new one I'm looking at, would there be an opportunity for me to stay in the UK legally within the gap? Because between the time I complete one course and find another and go on to that, there may be a few weeks, a month or so in between. In that case, would I still be legal?
So every student visa has expiry date.
Yes.
So your visa is valid from point A to date B. You
Mhm.
know when your visa expires, and therefore, if you have anything to do, you have to do it before it expires. As long as you do it before it expires, you have legally transitioned. And again, there's no break in leave, there's no gap. But if you do not do that, then if there's 1 month gap or whatever month gap, then at that point you were illegal. Of course, you can then move on to something else. But if you were illegal, in other words, if your visa has expired, you cannot switch anyway. So if the student is intending to switch, then they have to make sure that they switch before the current visa expires, and they
Now,
know the date, the deadline.
the question, sorry to cut you. The question is, when I have the expectation of moving on to another course or moving into a different institution for a higher course or a different course, I would have had to complete the one I was on. Now, when I apply to any institution and I say that I am on a course I haven't completed, obviously they will not take me. That's why I was asking the question that when I finish and have the admission into another organization, another institution, that gap in between, would I be illegal?
Okay, so normally student visas allow for time to prepare to return.
Okay.
So if it is 1 year course, your visa will be maybe 1 year, 3 months, or 1 year, 6 months, for
Okay.
example. So if you know you are finishing in June and your visa is expiring in September, you have to decide what to do with the gap, the period left. If it's a case that you intend to progress onto another course, then that arrangement should have been set out in place. for example, you know you are going to do this right from June, then you should have done all the applications and arrangement, and you have discussed this with the university. And it's
Mhm.
always the case with the same university. If you are doing it with the same university, it makes it even easier. But
Okay.
if you are doing it with another university, then the arrangement will be different. And therefore, you may experience a gap if it is something new that you are going to start with a new institution, a new course. But if it's the same course, let's say you finish the master's, you are progressing on to PhD, or you finished your undergraduate, you are moving on to um, master's. If the university is willing, they know how to issue your CAS,
Okay.
the certificate of admission to study paper, so that you
Yeah.
can use it to apply for leave.
Okay.
Once you receive that, you then see if you can apply in country. Of
Okay.
course, the arrangement will be in place. The university will then support you and guide you as part of the guidance process, information
Mhm.
and guidance process, so that they can assist you to apply within so that you have smooth transition. Or if that does not going to happen, they will give you a chance to go make an fresh application from your home country and come and continue. But it's the case that if you are moving on to another course and you wait for the visa to expire, then the chances are you will have a gap.
Right. Okay. Now, the other bit is when I have completed my study and I go on to this new program that allows me to stay in the country for 2 years. Now, when the 2 years are about to expire and I decide to pursue another course of study, would that put me back on a student visa route, so to speak?
So the program is over. You want to study again, so you have to start the process again as before.
Hmm.
So you have finished. You want to maybe study master's, so you want to study PhD. You
Hmm.
have to go through the application, apply, and just get a course again. But it's likely that you will have to then travel back to your country and apply from there to come and continue your studies.
Does a student visa lead to settlement?
So student visa count towards continuous residence in the UK.
Hmm.
Obviously, you are in for 1 year or 3 years or whatever your study period is.
Hmm.
There's no legitimate expectation that as a student you become permanently resident in the UK. No.
Yeah.
However, if you are counting the years you've been legally resident in the UK to decide whether you can make a permanent stay application or
Okay.
indefinite leave to remain application, then you count the years you've stayed on your student visa as well.
And so if I can accumulate 5 years as a student, then I could count all those and make an application for settlement. Can I?
So yeah, so if it's all been student throughout, that's why somebody will come in as a college student if they have money to pay,
Mhm.
progress to degree, master's, PhD, by which time they might have done 8 years. Then switch to something else. Then 2 more years. Put all together 10 years. Have you been legally resident in the UK for 10 years? Yes.
Yes.
Then they progress. So in this, so everybody has their own plan, and these are options that people have. But we are looking at somebody who came to the UK to study and they want to remain. And we have said that if you want to remain, you can switch to other areas, i.e., whilst you were in the UK, you had a child. Your child is a British child or EU child.
Hmm.
Then, as a qualifying child, there's opportunity for you to rely on their status to seek leave to remain with them so
Right.
that you can be part of their life and support their growth and development as a parent.
Okay.
So that is one option.
Right.
The other option is that you are in the UK as a student, you find love and you enter into relationship.
Hmm.
So you can again be sponsored by your spouse to remain in the UK with them.
Would that
That is
then
also
nullify your student status then?
remember we've already established that if you are a student and you switch to something else, you've switched. So that one, whatever you have is your new status.
Okay.
Whether you can continue to study or not depends on your commitment and whether what you have will allow.
Okay.
If you are on, for example, on a work visa or work visa, you cannot work full time and study full time
Mm-hmm.
unless then your university will accept that because you are now working full time and you do not need to keep to your student visa conditions in terms of attendance, we are going to vary your study for you. But you are an international student, and therefore, the university may not be willing to vary your leave from full time to part time. So, if you cannot vary from full time to part time, then you cannot keep to the full time expectation of the working visa that you have. On that basis, that may be difficult for the person to switch and still continue to study. But if the student has relied on his or her qualifying child for 2.5 stay or leave to remain in the UK, then what we are saying is that the university knows that you now have this leave. You have told the university your leave will allow you to study. You are paying your own fees anyway, so it's not a case of you are not a home student.
Mm-hmm.
Now, university then looks at your leave and say and tells you that now you switch to this, you don't need student visa, but you can continue to study. In this case, you cannot work. Mind you cannot then work and be studying without potentially affecting certain requirements on that studies. We are not looking at conditions of your student visa, but conditions of the study itself. So if you are, but the most important thing is that you are a student. What you want is legal residence. So you switched to 2.5 as a parent.
Mm-hmm.
That's box ticked. Can I continue to study? Depends on the arrangement you will have with the university.
Okay. Now, the other question I want to find or I want to ask is when I find a partner in the UK and I use that route to go to school. So it means that my partner is giving me a route to indefinite. Now I go to school. Would they consider me as a home student or a foreign student?
Right. So I think we've had a conversation about student visa provisions,
Mhm.
student finance provisions.
Right.
So you want a loan from the government through its agency, the Student Finance Company.
Mhm.
The Student Finance Company provisions or rules are that one, you should have been resident in the UK for 3 years at the time of application to them for support.
Right.
So count back. If you can't say you've lived in the UK for 3 years, then you have not satisfied the residence test. And
Okay.
it doesn't really matter whether you are a foreigner or you are a national residence test.
Mhm.
The next point is nationality test,
Mhm.
and per extension, EU, because the agreement and the EU provisions are that there is free movement of goods and services, so free movement of people. If you move to the UK and the EU program, you cannot be treated differently from somebody living elsewhere in Europe. And therefore, government is careful not to discriminate on those grounds. So
Mhm.
those with EU leaves fall under nationality arrange or test.
Okay.
So you have indefinite leave to remain, you have British citizenship, you have EU leave to remain or EU permanent leave to remain.
Okay.
Then your next thing is to meet the residence test.
Yes. Okay. So I did a course for 2 years. Then I took a gap year, which of course would allow me to have legal status to live in here as a student. Then I did um, my continuation of the course. That gave me 3 years. I met my partner, and I'm giving 2.5 years. I've spent a year on there. I've completed one course. I'm going on to another. A long winding situation. But in this case, I can count 3 years as a resident in this country. When I apply for finance, even though we're not talking just about finance, but if I apply for finance, would they still consider me and give me a loan to continue my studies?
So the first test is, have you spent 3 years in the UK at the time of application? If the answer is yes, you've met that test. Then we move on to the second test. Are you a UK national, a person settled in the UK, or a person with EU leave to remain?
Mhm.
If yes, then you have also satisfied the nationality test. Then you'll be accepted.
Accepted.
Your
Okay.
application will be accepted for consideration.
Well, we have a few more minutes to the very top of the hour. I have one Daniel Kwekuredu asking this question. So, lawyer, I'll put it on there. From lawyer's explanation, I'm a student in the UK. I'm done with my classroom work. I'm working on my thesis. Will my switch be so restricted by this trade off? And he continues to say, given that I have less contact hours with lecturers.
So the answer is derived from what I said, that all these are specific arrangements that individuals will have with their university. So if now you have completed your classroom program, you are doing the field work or the thesis, no
Mhm.
contact hours, but you are still a student with certain conditions to be met per
Right.
the study program. So if the university allows that, you are now about to finish, and therefore you can live your life as long as you keep to your research or your project work conditions, so be it. But
Mm.
the answer to Daniel will only be relevant, or our brother will only be relevant to his or her to his university, and also the answer to maybe Mabel or somebody else will be relevant to her university. Therefore, it's a case by case basis.
Okay. Well, Nana say also comes in with this question: does the 2 year postgraduate visa count towards the route of settlement?
So government has been clear that it's just a steady work experience concession, and therefore
Mhm.
doesn't count towards settlement.
Okay. Then finally, before I move on to my next question, Laura, Felix is asking, when applying for a student visa from Ghana, can I use my pound account in Ghana as a requirement?
Pound account. I mean, your account is your account. It doesn't matter the currency. It's even better in terms of conversion that it's in pounds, isn't it?
Well, you get more towards your education. In any case, lawyer Charles Asmah is helping us to understand what the options are for students in the UK when they are about to get to the expiry of their visas. What are my options to remain in the UK if my student visa is about to expire? Lawyer, you've mentioned changing to a different route. You mentioned getting a partner, um, maybe standing on the basis of your child and the rest of it. Are there any other options that are available to students to kind of go through to remain legally in the UK before their things expire? Or when they expire, what do they do? Is there any other route?
Yeah, so we've looked at before it expires, you can switch or you can transit to other areas that
Hmm.
we have mentioned. What if, for whatever reason, it's already expired?
Yeah,
It is not the end of the road for you,
right.
provided having lived in the UK illegally for a while, you have become a father to a British child or EU child, then you can rely on this child to apply, whether you live with a child or you don't live with a child, provided you can prove that you have parental responsibility in terms of your name appearing on the child's birth certificate as the father of this child. Then you can apply under direct access provisions if you do not live with a child, or apply as a parent living with their child if you are living with the child and the mother. Of course, you can also apply to remain here in the UK with your spouse. If having lived illegally for a while, you have met and married in the UK. In this case, you apply as a partner. However, there are instances where the caseworker will conclude that if you are married and so much in love and want to spend the rest of your life together, then it doesn't really matter where you live. Therefore, you can go back to your home country and spend your marriage life there. That is a very harsh conclusion that sometimes they draw. But if there are insurmountable obstacles which may prevent you from surviving in your home country, then that is something that you can put in as part of your plea as to why you should be allowed to remain in the UK.
Well, ladies and gentlemen, we're live on BWtv, live on BW Radio. What are my options to remain in the UK legally before my student visa expires? Lawyer Charles Asmah, our legal expert, our friend and our brother from BWF Solicitors, is right here with us, explaining the options to us and how we can go about that. Now, the question then is, how do I make that application? What do I need to put in to make that application? We'll take a break now and say thank you to BWF Solicitors. And when we come back, we'll go to that aspect of the questioning. Then, of course, we'll take your concerns and questions live from our studios here in the UK. So if you have a question, please put that on the platform, either on Facebook or YouTube or any other form of media. You can send a text to our text message line. Yeah, we'll try and find a way of getting that to me, and I'll read them for lawyer to answer for us. So we'll take a break now. I'll be right back live on the community and the.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, so if you have any question or concern you would want to bring across, you can text it to 07950422780. The lines today are not active, so just send your text, your WhatsApp messages to 07950422780, and that will be transferred over to myself for us to look out for you. What are the options for you to remain legally in the UK before your student visa expires? Lawyer Charles Asmah is our guest and resource person from BWF Solicitors. In the meantime, let's say thank you to BWF Solicitors for their proud sponsorship of this program. Lawyer, yes, we are back, and let me find out from you if I have put myself in these categories. I've looked at these options and I'm trying to pick up one of them. What does a student have to do?
Right. So the student wants to apply to remain in the UK.
Yeah.
Now, it doesn't really matter the fact that the person is a student. That's not what we are looking at.
Hmm.
So it's not who are you. The person is making an application to remain with the child.
Right.
So this will fall under Appendix FM. They have to prove that they have a relationship with a child in the first instance.
Okay.
So what's the relationship? And here they have to prove it by either DNA or birth certificate. The birth certificate is always the case. It's easier because if the child was born in the UK, then UK birth certificate is not questioned. So birth certificate proves that you are the father of the child, if it's a father, or mother of the child, if it's the woman doing it. The next thing is, how do you show that you contribute to the support and care of your child?
Hmm.
So the support and care test is that as part of caring for the child, you are there. And the law puts it this way, that you play active role in the life of the child. So how do you prove that you play active role? Day-to-day development of the child. Are you in the life of this child? So school. If we go to the school to find out, will they say that yes, they know you to be the uh, emergency contact person or the father or mother of the child? If so, they will provide a letter.
Hmm.
Or we go to your GP or the GP of the child, the GP. Would the GP confirm that yes, this father or mother of the child is on record as such? And sometimes they come along with the other person for the child to have his or her appointment. If that's the case, then that's also proving that you are in the life of the child. What about the parent, the other parent of the child? Would the other parent also confirm that yes, you are there for your child, and that without you, the child will struggle to survive because of other things the other parent is going through?
Hmm.
Then, in this case, everything points to the fact that you play a role in the life of your child. So you've met two things. Depending on what you are seeking to do, whether you want to apply under the 5 year route or under the 10-year route, what you have to show is based on the specific route um, criteria. So under the Appendix FM, for example, under the 5 year route, you have to show that you are working
Hmm.
and that you are making at least 18,600 a year,
Okay.
and you have accommodation, you have done the English language test and
Yeah.
passed. All this put together will then add to the relationship and the care that you put in your application using the right form. An application is online. You pay your fee and you pay your IHS fee and you submit your application.
Okay. There's a question from Covenant Grace, and I will want to pick that one up for her to help us address that. If I entered the UK as a student and my child's mother also entered with my child on EU family permit, can I use direct access to my child to switch to Appendix FM, the child and the mother have pre-settled status.
So your child becomes a qualifying child.
Mm-hmm.
And as a father of a qualifying child, you can apply under direct access provisions, or you can apply if you are living with the mother and the child. If you are
Okay.
not living with the mother and the child, that's where direct access comes in. So let's take note. In this case, the mother will vouch that yes, you play a role, and the school and GP will also confirm that they are aware that you are the other parent, or you are down as the emergency contact. Then that can also support. Yes. So that is also an option for this individual.
Okay. Besua, I think the problem must be from your end, so please check your gadget. Delali comes in with a question which I just want to put across that if you have any question at this point in time you would want to put to the lawyer, just come along with it. Send it as a text or WhatsApp to 07950 or put it on a platform either on Facebook or YouTube. We'll pick that one up quickly for you. Now, Delali says, can someone on a 10-year parent route get indefinite when renewing their visa for the last 2.5 years?
So the person says the last 2.5 years. That means they haven't done 10 years.
Yeah.
Yeah, if you haven't done 10 years, you cannot jump to indefinite if you have done 7.5.
Right. So obviously, then you have to go the same, the full
You have to
length of
finish the full length of 10, because 10.
10 years before you can do that. Okay, lawyer. I came in as a care worker through the route, and in the course of it, I found a course or a school I want to go to, so I develop myself. Is that possible?
Everything is possible provided you meet the conditions of whatever you want to do.
Hmm.
So this person has come in to work for company A.
Right.
This person is here with 3 years or 5 years visa.
Yeah.
And there are conditions. Work for company A. So in terms of work, you are working. But if you decide to go to school, can you do full-time studies and still meet the conditions of your visa sponsorship?
Hmm.
If the answer is yes, then nobody is coming to ask you why are you studying and working, provided you can pay your fees.
I seem to get the thrust of this person's question. Now, as a student, he has legitimate right to stay within the period that he is going to school. As a worker, he has a legitimate right to study to stay in the UK for the period of his contract. These are two legitimate situations, but he came through one route. Can he switch to the other?
To where? To student?
Yes, or vice
I don't,
versa,
I
or
don't
from
know why anybody would want to switch from 3 years to 1 year, for example, unless it's accidental. Or if for anything, you want more leave.
For instance,
But
I
just assume that
don't feel like doing
they
that
choose
job
to study.
anymore.
They choose to study, and therefore they've now realized that they've made a mistake wishing to work.
Hmm.
So they are moving to study. So you are going for student visa. Now,
Right.
once the certificate of sponsorship is issued to you, the chances are you have to make the application from home country.
Okay.
As I said, there are flexibilities. There are instances the university will also have a plan in place to allow you to make the application from here if they think that what you have is. But there's no there's no rule at this stage set in stone that because you are studying, because you are working, you can
Hmm.
switch to student and apply here. Earlier on, we said that if you're already a student and you want to progress and the university allows it, you then be able to make in-time application to continue.
Okay.
However, if you're on a work permit and you want to go to school and the university offers you admission and gives you the CAS, you have to go to your country and apply to enter to study because
Okay.
you came to work. If you choose to study, you have to go and apply for a new visa to come and study.
Okay. Well, I think more of continuing something on the question I posed. Upsound Acrobi says, I've switched from student to skilled worker visa. Please, does my 1 year stay on the student visa count to indefinite?
So indefinite is amalgamation of um, all your legal leave in the UK, the legal residence.
Right.
One that is contentious is the 2 year study, post study, where the government says that this will not count towards settlement. But I'm sure even that with time there could be a change. However, this person has stayed on a student visa. This person has stayed also on this new program.
Hmm.
But the new program alone, the presumption is that you are going to stay on for 5 years,
Okay.
after which you apply for indefinite leave to remain.
Right.
So you won't say that I've done 4 years on the program, I have 1 year already in the bag for me. So instead of me waiting to do 5 years with my employer, I'm moving to indefinite. No, you can't cherry pick.
Okay. Right. Um, Another thing is another question, so to speak. I came here as a partner of a skilled worker. Now our marriage is broken down, and we seeking for divorce. What happens to me as a partner when the divorce goes through?
All right. Remember, you are a dependent
Hmm.
of a student or even skilled worker migrant. And what links you to this person, the main person? Because it's not about you. Quote and unquote, the law does not look at you or to you. It is the main person, the student, or the main person, the skilled worker migrant.
Okay.
Once the main person is okay, that is when you are okay.
But now they're
And that,
divorced.
but now, if you say that I don't want to belong to you anymore, then you cannot have what they have.
So in that case, the partner who came in as a dependent will be deported, right?
Well, we are not talking about deportation. That is a matter for the government.
Hmm.
We are talking about whether a person can be legitimate or legally resident in the UK. And the answer is no. For the moment you are not a dependent, then you cannot rely on the dependent visa you had.
Okay.
Therefore, you have detached yourself from the main person who has the means to remain in the UK. And what they have is what you get. So the moment you go through divorce and the relationship is broken, then your visa is also broken. Whether you are going to be deported or not is not a matter for the lawyer. It's a matter for the government.
Okay. So in that case, when there's divorce, when there's a breaking relationship, definitely your visa is broken and is null and void, isn't it?
Yeah, yes, Brakoku. I mean, it's as simple as that. You see?
I
Yeah,
like the example, and that's
yeah.
why.
So if it's no longer, then there's no dependency. So you are not a dependent. So what
Right.
they gave you is no longer for you. Maybe they'll give it to somebody else. Yeah.
Oh, this one
So
says, yeah, this one says, I'm a university student and I want to switch to support worker or any other job that will issue tier two visa. How do I please go about it? It doesn't matter if it involves a fee.
well, you look for companies that are the company that um, have advertised vacancies.
Hmm.
Once you find one, if you have the skill set, you apply. They will, of course, take you through the interview process. If you are successful, you'll be issued with sponsorship certificate. Then you use the certificate of sponsorship to apply for your leave to remain in the UK as a work permit holder. If it is under the skilled worker program, then of course you go on that. You remember before the skilled worker provision came, there were other people. The people were on work permit.
Mm-hmm.
So work permit is not new. Just that it's been refined and tailored to specific needs. But if the employer has the power or licensed to give you sponsorship to work for them, then you can do that. So our brother who asked the question, please go online and look for job, especially if you have passion, experience, or some skill in care. You can go online and look for care work in the UK, find companies, contact them that I've seen this vacancy, I want to apply. You can speak to them in advance, or you can just go through the process. Yeah, but
Okay.
to say that even if it's for a fee, no company will offer you employment and charge you. The law doesn't say that. So I will not even accept that you mention a fee. The fee only comes in if you have got a sponsorship and you want to make your visa application. Then in this case, we as lawyers, if you choose for us to do it for you, will charge you our legal fee. And the Home Office will also charge you the visa fee. That is where the fee comes in. But the employer will not charge you a fee, as far as I know.
Okay. You can send in your text to 07950422-780, or write that on the comment section of our Facebook and YouTube pages. Absanda Krobi comes in again. Please, there any magic from BWF to relocate from skilled worker to something else? Is there any magic you do, sir?
So it's saying that is there any magic for BWF to relocate skilled worker visa to something else? You see, we apply law. We don't apply the magic wand. So that's the first point. The second point is that if you are switching from skilled worker to something else, they will look at whatever thing else that you want. And I think, Bakoko, we have been clear that if you are in the UK and whilst in the UK as a skilled worker, you have a child and your child is British or EU person or child, then you can depend on the child to now move from working for that person with your work permit to something else, 2.5 as a parent of a British child. That's possible. Whilst in the UK, you marry you find love and you marry your wife or husband. In this case, you can switch from what you have to something else. And on that basis, you do not have to work for the employer anymore because you are no longer on that arrangement. You are on your own, so to speak. But as to whether BWF will find out something else for you, we are a legal firm applying the law to assist you. So if you come to tell us that this is my situation, advise me, then we use the law to advise you. But we don't tell you that this is what will fit your situation without you
You don't,
telling
you
us
don't,
what your
you
situation.
don't, you don't do magic.
Well, we have to then understand what he means by magic, and that's why I'm going on about the explanation.
Anyway, can someone on the care worker visas route switch to a new care employer who is happy to issue him a new certificate of sponsorship to work full time? The previous employer has no regular work for him. Living cost is getting higher and harder. How does he go about it?
Yes, so the answer is yes. You can switch from existing employer to a new employer. The new employer must be willing to sponsor you, and how to go about it is the same way that you went about it to get the first one.
Mm, okay. All right. 07950422-780. That's the text WhatsApp message platform. Send your questions, your concerns to that. Or you can come on Facebook, YouTube, and put your questions and concerns there. Lawyer one here says, please, as a child who holds a Ghanaian passport with pre-settled status and a mother holding Ghanaian passport with pre-settled or settled status, all derived from maternal grandparents, a qualifying child under Appendix FM.
So it's about a child. So we are not even looking at what the mother has.
Mhm.
This child has pre-settled status. What it
Yeah.
means is that the grandparent had pre-settled. That's why the child was given pre-settled. Otherwise,
Okay.
the child would have been given settled. But whether pre-settled or settled, the child is a qualifying child.
Okay.
But it's
So
not under appendix. So
FM.
you see, it's not about appendix FM per se. The law says that a qualifying child must be X, Y, Z, and therefore, once the person has pre-settled status under appendix UU, the father or the mother who wants to rely on the child to apply will apply under appendix FM. So yes, we can say that the child is qualifying child for appendix FM application of the parent.
And what would the particular mother or parent be giving? Is it a 2.5 or a pre-settled status or indefinite work?
I suppose the person said that the mother also has 2.5 or has something. Anyway, whether it is the father or the mother who is depending on the child or relying on the child to apply, the application will be under appendix FM. And this parent will be given 2.5.
And
And
would it be the 2-year route or the 5-year route?
depend on whether they met the requirements. So there are two gateways. The 5-year route will tell you that if you are coming in, come as a direct access parent. And if you come
Well,
in as a direct,
I mean,
you come in as a direct access parent, you have your conditions met: English language, finance, accommodation, relationship, everything met. You apply. Of course, suitability is always set in stone that you will not be unsuitable. So once you are suitable, fine. Then you apply for 5-year consent, 2.5 under the 5-year route. The second one is if you do not meet some of these requirements, English language, you do not meet the finance and this and that, then you'll be put on the automatic route, the longer one, 10 years. But still be given 2.5. So you either go with EX1, exceptional circumstance grant 1, with 3.2 general provisions. And therefore, what the person is saying that I am a parent of a qualifying child. Either I live with a child or I don't live with a child, but I do not meet the requirement. And therefore, I should be considered under the long route.
okay. So I'm thinking of a scenario like this. The child is a qualifying child under EU. The parent comes from, for purposes of our discussion and example, holds a German passport and will want to come and live in the UK. What will happen? Would the parent be giving 2.5 years and having met the English and all the other criteria go along the 5-year route?
What you are telling me is that this parent is in abroad
Yes.
and they want to come to the UK. But the question is, why are they coming to the UK? To take care of their child.
Or to live with the family, so to speak.
If they are
But
coming to live, if they are coming to live with the family, then it might be that there's an adult somewhere who may be sponsoring this person's application. But if you tell me that they have a child
the
in the
parent will
UK,
be
so they are
depending on the
coming,
child. The parent will
so
be depending on the child. Yeah.
so the moment you say that the child lives in the UK and therefore the parent must be here for the child, then we are talking about child's welfare.
Okay.
So it might be that the care is not adequate, so parent must be here. Of course, you have a right to be where your child is,
Your
but if your
child.
child is okay, then to what use is that right?
Okay.
Because it's not about you,
It's
it's
about the
about the
child.
child.
That's
And
right.
therefore, if the child is okay, let's say they are living with their grandparent, so they are okay, then what's the point you coming
What
in?
time you coming
But
to
if the
them?
child is not okay and you need to step in, then you are coming in the best interest of that child. Now, if you are coming in the best interest of that child as a parent, you apply for entry clearance. Remember, the child is not in the UK to exercise treaty rights because they are not adult.
Okay.
So somebody who was exercising treaty right brought the child. So if you are applying from outside to enter the UK to take care of your child, who is a qualifying child, then your application will go um, under Appendix F from human rights application. Because you cannot rely on EU per se. But if it was an adult and you are coming to live with this adult as a dependent of that adult, then the person will be a relevant person under EU Appendix EU provisions. So those are the dynamics. But yes, your child lives in the UK. You have the right to be where
Okay.
your child is, provided the child actually needs you.
Okay. Messi comes in and says, does the old certificate of sponsorship need to be cancelled before the new employer issues a new one? Or once the new visa is issued, the old certificate of sponsorship get cancelled automatically?
So it's always the case. It's usually the case that you'll be given time to find a new employer and to switch.
Mm-hmm.
Because the moment the existing one is cancelled, how do you switch? Because you cannot switch on empty ground.
Right.
So you switch whilst the first one is still valid. So if the employer wants to offload you to another employer, they will give you time to find and to switch. But once you find one, the moment you make the visa application, you've switched, and the old one is no longer the case, or the
Okay.
existing one is no longer the case.
Yes, time flies when you are in good company and you're having fun. We're moving on. We have a few minutes to pick up your concerns and questions again. I'm here with my wife on skilled worker visa, but I currently have a child with another lady who is on EU pre-settled visa. What problem or benefit can I have? I like that.
Okay, so I'm here with let's break this down, with my skilled worker. Currently, we have a
Wife,
child with
yeah.
I have a child with another lady who is EU. So the child has become a qualifying child, I suppose. Okay, so I have a child with a lady who is on a EU pre-settled visa. Okay,
Mhm.
so we have to then settle the child and consider settling you, the father.
Okay.
But the mother is already on a pre-settled status. So the mother doesn't need to be settled. So there are two people here, the father and the child. The child is not settled yet. So we have to settle the child by applying on the basis of the mother. And once
Mhm.
the child has his or her leave, the child, because the leave is under Appendix EU, the child becomes a qualifying child under the provisions. Then you, the father, with a qualifying child, if you wish to remain in the life of this child, will apply as a direct access father or as a father living with the child mother and the child to make an application based on your status as a parent.
Okay. Now that every institution is
And that will come under Appendix FM. So just to add to that.
okay, all right, thank you. Now that every institution, especially care homes, are looking for those who can work full time, I'm also a student who wish to switch from student visa. How do I get such homes to, first of all, switch for me when I don't qualify to work full time? If they are recommended care homes, then I entreat you to assist me because have worked for an agency as a support worker for the past 7 months, and now the shifts are no more coming.
I'm happy that our brother is a student. I'm sure he's studying master's or first degree.
Mm,
So they will have to go online. I'm happy that they can research online and find jobs. It
mhm.
may take some time, but that is how everybody will do it. So you research, find a job, and apply to them. And once you go through their process, you will be offered sponsorship. You can then apply to switch if your visa is still valid.
We are live on BW Radio, BWtv. The program is The Community and the Law. If you just joined us, what we're discussing is that what are my options to remain in the UK legally before my student visa expires. Lawyer Charles Asmah from BWF Solicitors, our sponsors, is here with us, taking us through your questions, your concerns. He's explained how you can go through the various options and situations and scenarios available to you. We've looked at what applications you can put in. People are also coming in with concerns and questions, and he is graciously answering all of them. The point here is if you want the best of lawyers to deal with your issues here in the UK, I'm recommending that you speak to BWF Solicitors. They work Monday to Friday between 9:30 in the morning and 6 p.m. They are on the fourth floor of Vienna House, 214 to 218, Tottenham High Road, Seven Sisters, North London. Call them 0208 493 7340 or 077 127 61884. 077 127 61884. Thanks, AFK Smith, Mercy, Upsound Akrobi, Tilly Duma, Covenant Grace, Nana Ose, Amwa Samuel, Delali Gomado, and all the wonderful Felix Asante, Wumpini Adam, and all the wonderful people that have joined us on the line, Daniel Kokuredu, and all the wonderful people. I say thank you very much. So if you are here, let's hear about you. Let's hear of you. Give us a comment, send in your text, your shout outs. And of course, please pick up the link and share with other people. Now, remember this link is live, but it will be on our platform, BWF Solicitors, BWtv, forever. So if you missed a live one, you can go back and watch and get answers to your questions. But as well as we're live, you can send in your text 07950 422 780 07950 422 780. Now, lawyer, let me find out from you. So if I am on a course, prior to me completing, I would have to resit some papers, which means that it may take me over and above the period that I'm allowed in, 1 year and a few other months. What happens to me? Can the school give me extra concessions so I could stay in and complete my course?
The universities have welfare programs to cater for things like this, depending on what the course is.
Okay.
So if it's a mitigating course, then if it's the reason is tenable, then the university will, through its counseling programs, say that right. This sometimes the university will even put in a word on behalf of the student that whatever happened is beyond the control of the student, and
Right.
this has affected the student, and this will be, and it is possible that this could happen to any student, regardless of their level of intelligence. And so it is not that they are lazy to learn and so they didn't pass, but it's a case that they went through certain hardships. And so the university would then give them concession in terms of extension and give them, they still have to be issued with certificate of admission to study so that they can apply for a top-up leave, so that they don't have to go back to their country and start the process of application from there. So there are instances like that, but it's case by case. And therefore, if somebody is in that situation, and of course, if it's happening, they know it's happening. So they have to take steps to deal with the student at the university, go through the student union of the university, go through the welfare support system of the university, go to student services department of your university, discuss this with them, speak to your lecturer or supervisor, let them know. Then they'll put a plan together to assist you. The university will be flexible enough to allow them to switch or to apply again from the UK.
Okay. What will be the stance of my wife depending on me? My wife depending on me on my current skilled worker visa. The stance of my wife. Definitely, your wife will be coming in as your dependent, isn't it? So I assume that the amount of time you have on your visa is the same amount of time your wife will have. Lawyer, would I be right?
Yes, it is the case. So, if, for example, your partner applied around the same time as you applied to enter the UK, then it's likely they will have the same amount of years as yourself. But if you came in on a 3-year sponsorship leave or visa, and after 2 years your partner joins you, your partner will not be given 3 years. so that they will have visa whilst yours expires within a year. No, they will get what you are left with. Then both of you will renew together.
Okay. The other bit is you have a partner and your children. How many children can a skilled worker bring to the UK? Would it be if you have 10, you can bring all 10 of them?
The law says you can migrate with your dependents, that's partner and children.
Would stepchildren be included?
The law says children. Stepchildren are your children. But what then it is that, um, but if the child is your stepchild, obviously that the step so depending on how it is, you are the main applicant.
Mm-hmm.
The child is your stepchild. That means the child is not yours.
Mm-hmm.
If the child is not yours, then the child has a father. The child has potentially a mother
Okay.
or a father, depending on who you are. If there's a father or mother somewhere other than the other parent, then they will ask the child to demonstrate that this parent has the right to decide where that child should live. So responsibility. So
Oh,
this step parent will have to prove that the child has nobody else. Maybe the other parent came into the relationship with the child alone because the other parent is dead, or the other parent has whatever, nobody knows. So then we can put all these pieces of evidence together. But the caseworker will come back to fish for more reasons why the child should be allowed to stay in this new environment with the step parent and the other parent.
there's one interesting question. We'll pick that one up before we go for a break and come back for our nugget again and our quiz for the day. Lloyd, this person is asking, how long do I have to marry before I divorce? I'm asking this question because it's married 1 year, and 1 year into the marriage, there are issues, and the person wants out, and they are living in the UK. Somebody's told me that my marriage will have to uh, be in place for 3 years before I can divorce. Is that correct?
So we have the law of the law
Hmm.
and the law of common sense.
Okay.
The law of the law is that once you marry, stay and exit for good reason after 3 years.
Okay.
That's the law of the law. The law of common sense is that once you marry, if you are suffering harm and abuse,
Hmm.
leave before you die.
That's common sense.
That's common sense.
Hmm.
So it depends on what the person is leaving the relationship to achieve. If the person is exiting the relationship to safeguard their life, then you don't look anywhere. You just want to protect your life. That is where, for example, domestic violence concessions would be relevant to such a person if they came under Appendix FM or Appendix EU or refugee um, convention programs.
Hmm.
But the law is that you marry, you can divorce after staying with your wife or husband for 3 years. So more or less, you get a free exit after 3 years. But before the free exit is granted or ready to be issued for you to go for,
Hmm.
what do you do if you are suffering? And my position, this is my position. It is not the law. My position is that you don't suffer and expect to exit 3 years if you don't end up living up to 3 years.
Yeah, that's
So
common sense.
as that's common sense. As soon as there's no reason, you have to exit. But if there's reason, with a view that it will work out, then you stay on. But you don't have to at the expense of your life, because life is once.
So In from the lenses of the immigration um, casework or the Home Office, if you exit before the 3 years and it's not for domestic violence reasons, then your stay, whoever is depending on the other, the person's stay is kind of become null and void.
So that is where the person will say, what then happens to me?
Mhm.
It is not them, it is their stay. Of course, the stay is for them. And I want us to separate life and anything else.
Yeah.
So you have life and you have your leave to remain, which is linked to your partner. And therefore, you are suffering, and because there's no domestic violence concession, and because of your leave, you sacrifice your life.
And when the time is up, you will not be
And there's
available.
no life, then you can't even have the leave. So it's a matter of holistic assessment of what is best for you under the circumstance. And if you are in doubt, seek legal advice so that the lawyer working with you will assess all your circumstances and say, under the circumstance, this will be best for you.
Okay.
But what we are saying is that you can divorce after 3 years of marriage. And now in the UK, you don't have to prove fault. And the laws have been simplified under the new um, divorce regime. But if you divorce elsewhere, abroad, in other countries, you have to go through the same legal process that you would have gone through if you were to divorce in the UK. So that as long as the divorce certificate is issued by a court of competent jurisdiction, then it's allowed or accepted in the UK. But if it's not issued by a court and you present as your divorce certificate, UK will not accept it for immigration purposes. So, for the purposes of our conversation, I would say that whoever is in that dilemma or quagmire should seek legal advice to assess their case holistically, whether they should leave as soon as possible or they should stay on for a while.
Okay. Well, Lawyer Charles Asmah, thank you very much for your generosity because you're sharing free knowledge and experience with us, and we're so very grateful. We're taking a quick break, and when we come back, we'll be looking at our nugget again and then the question for the day. Our quiz, when it gets to that point, I get so excited because now we test what knowledge we have acquired and how we can remember that and how we can apply it to any situation that confronts us. It's the community and the law, and it's brought to you by BWF Solicitors, our trusted legal partners when it comes to the law. We'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
BWF Solicitors are trusted legal partners. And yes, call them 0208 493 7340 077 61884. Now, this one says that the domestic violence concession under the UK immigration rules does not cover partners under the skilled migrant worker route. They cannot therefore rely on the concession to settlement even if they suffered domestic violence by their partners. This is because such spouses are not considered to have legitimate expectation to live in the UK permanently. The concession only covers routes under Appendix FM, those here are spouses, refugees, and Appendix EU after Brexit. As I said, this is English and Wales High Court ruling, the case number 2067 of admin. Well, lawyer explained earlier on all the details there, but then the question here is, Abiba Akos joined her husband Isaka in the UK as a health care worker dependent in January 2023. Unfortunately, Isaka subjected Abiba to prolonged periods of domestic violence, including sexual assault. Abiba contained non-molestation and occupation order obtained, sorry. Abiba obtained non-molestation and occupation orders against Isaka. She subsequently applied for the destitute domestic violence concession so she could continue to stay in the UK. Unfortunately, the application was refused. Abiba said no way and appealed against the decision. Abiba Akos, I'm going over the scenario, joined her husband Isaka in the UK as a healthcare worker dependent this year, January 2023. Unfortunately, Isaka subjected Abiba to prolonged periods of domestic violence, including sexual assault. Abiba didn't sit back. She obtained non-molestation and occupation orders against Isaka. Subsequently, she applied to the Home Office for the destitute domestic violence concession so she could continue to stay in the UK. Home Office said, no, we can't give you that concession. She appealed against the decision. Now, what is likely to be the outcome of the appeal? One, as Abiba has suffered domestic violence, her appeal will be allowed. Two, as Abiba is in the UK as a skilled worker dependent, her appeal will be dismissed straight away. And three, as the court granted Abiba non-molestation order, her appeal will also succeed. Well, Abiba is, or somebody choosing number three will say, well, apply for non-molestation order, you granted it, this person cannot come near me and all the rest of it. So why can't you give me the opportunity of the concession? So is it one? Is it two? Is it three? Now let's see what you have. Put your answers on the chat or send a text. Kevin Asamoah says the answer is number two. As Abiba is in the UK as a skilled worker dependent, appeal will be dismissed. Well, that's what Kevin says. Let's see others. Well, Sandra Corte, unfortunately, we didn't get your question in time. Sorry, would have to skip that. We'll come to that next week, maybe. Kevin, yes, we have your answer. Who else is coming? Is it number one? As Abiba has suffered domestic violence, her appeal will be allowed. As Abiba is in the UK as a skilled worker dependent, her appeal will be dismissed. Or three, as the court granted Abiba non-molestation order, her appeal will also succeed. Well, that's commonsensical, isn't it? Tracy Awua says B, that's number two. As Abiba is in the UK as a skilled worker dependent, her appeal will be dismissed. My inkling is to number three, because if you could grant me a non-molestation order, my appeal should succeed. But is that what the law says? Let's hear you. Text 0795042270 or put that in the chat here for us. Okay, now time and tide they say waits for no man. So Ademununkum says number three. Yes, Ademunikum kind of agrees with me, doesn't he? Okay, now let's hear what the lawyer says. What explanation would he give? And well, Kevin says since she's on a dependent visa, the appeal will be definitely dismissed. My agreed do Mensanta Magi says number three. Yes, kind of agrees with me because it makes common sense as it did. As a court granted the non-molestation order, it means that you are accepted that the person is abusing me. So then, why can't I enjoy the concession? Lawyer.
Okay. Thank you to viewers and listeners for this active participation. There's no right or wrong until we look at what the law says. The law says, under the case we had today, the case of R, that apart from Appendix FM visa holders, refugee visa holders, and Appendix EU visa holders, any other visa holder on any other route will not benefit from domestic violence concession. That's point number one.
Right.
Now, Abiba, we have to check which of the provisions she came under. Was it Appendix FM? No. Appendix EU? No. Refugee concession? No. She came under Appendix skilled worker because the partner came as a skilled worker and she joined the partner. Now, why is it that the law is protecting her from harm and abuse? The law is not respecter of person, therefore the law protects everybody. So there's the law of protection and the law of immigration. So the law of protection will protect her from the husband continuously abusing her. So the non-molestation order and non-occupation orders were granted so that the husband will not go close to her and will not do what he was doing again. But in terms of whether she can fast track her leave because she's been abused to get indefinite, the law says she doesn't because she's not one of the three. She's not she didn't come based on Appendix FM, she didn't come based on EU, Appendix EU, or she didn't come based on refugee status, and therefore she will not. Even though she will appeal, the appeal will be dismissed. Answer is 2.
The answer is two, and I think Kevin, Asamoah, Tracy, you got that correct. Kevin even went on to give an explanation as to why he thinks that the answer is number two. And Kevin is asking, do I have another T-shirt? Kevin, no. Well, the answer is number two. Concession gives certain applicants a 3-month period to leave of leave to remain in the UK. It acts essentially as a springboard to apply for indefinite leave to remain under Section DVILR of our Appendix FM of the immigration rules. The concession was that those who came to the UK as a partner of a person with a temporary work or study visa had no legitimate expectation of being able to live here permanently. Whereas other categories of partners, for instance, spouses of settled persons and refugees, would have such a legitimate expectation, as a case we quoted in there, a lawyer has graciously explained. And with that, let me go over to lawyer Geng for him to do the closing remarks. Then I will come to draw the curtains down for today's program. Lawyer.
Thank you very much, viewers and listeners, for keeping faith with us. Today, we have asked ourselves what options there are for students living in the UK, and especially what they can do before their visas expire. We have discussed and seen that while they are in the UK, before the visa expires, they can switch to Appendix skilled worker provisions to become a skilled worker permit holders. Or if they have children whilst living in the UK and the child is a qualifying child, i.e., British child, EU child, or the child has lived in the UK for 7 years, which may not be the case for most students because the student might not have lived in the UK for that long to have a child who would have been in the UK for 7 years or born here and lived in for 7 years. So we're looking at where the child mother is EU and therefore the child has pre-settled, or settled status, or the child is British, then the father can't depend, or the mother can't depend on this child who is a qualifying child under the relevant provisions of the law. Then you can switch to Appendix FM visa and be given 2.5 as a parent. Or you've married the child's mother and you have become a stepchild. In this case, the child is not your child, so you cannot use direct access, but you live with the child and you live with the mother of the child, who is your wife. Then, in the best interest of the child, you'll be given opportunity to continue to support the care of your child. So you then apply as step parent of this child, and chances are you'll be granted 2.5, provided you prove that you've married the mother of the child or the father of the child, and the child is a qualifying child, and you are in the life of the child, supporting in the care of this child. Or you marry but there's no child in between you, or there's no child into the relationship from the other side, then it's just you and your partner. Chances are you will be considered with leave to remain so that you can have your marriage life. Or you may be asked to go back to your country, which we don't expect. So we are not really going to, but it is the option that the Secretary of State can exercise to let you go. So you can see that where there are children involved, it makes the cases heavier and the chances higher. So that is the note will sound at this stage. Now, if that is not the case, you can apply to continue on the studies, but again with arrangement with the university where you are studying. In all this, you have to make sure that you do it before the visa expires. If the visa expires, then you have to make sure that, of course, you either go back to your country or you remain. Whilst you are remaining in the UK, you have illegal status, then you can then apply onto any of the routes that we have discussed, based on your child, based on your wife, but you cannot switch because you have no visa based on which you can switch to another area. We don't expect students to stay for 20 years before they apply, because that is not an option. So it's an option, but not a very good option. So we are not going to mention that. So those are the potential options that are feasible in the circumstance of these students that we are dealing with. Of course, we also know the almighty post-study leave that you can apply onto 2 years. And at least within that 2 years, you decide how you want to navigate and remain in the UK. I believe that these conversations today have given a breather of hope to students who are wondering, what do I do? And we believe that students will take advantage. However, if you need further advice or further input, please do not hesitate to speak to a lawyer who will be able to use the law to assist you much better. Thank you once again for making time with us. Join us again next week, Thursday, Friday, and Saturday.
Well, need I say more? I just have to say thank you very much to Lawyer Charles Asmah on behalf of everybody that has been part of the program and contributed, and to my production team, Sheila Ankra, to Padmo Dudu, and my studio director and producer, Professor Ade, to BW Solicitors, the lawyers, and all the supporting staff, both here in the UK and in Ghana. I want to say I salute. And on behalf of Na Manyeti, my co-presenter, we say have a very good week. Please be good, and we'll be back again with you same time next week. Until then, keep the love afloat. We're out in grace and style. Good evening.
Yeah. Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Oh, 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 Everybody say,